All of that pent-up frustration, animosity has finally spilled out into the public.
NASCAR just took a hit no one saw coming. What began as a quiet legal standoff has exploded into a full-blown courtroom showdown. And for once, it's not the teams under pressure, it's NASCAR itself, and the consequences could be massive. In the fast-paced world of motorsports, few moments have rattled the system like this. The ongoing legal clash between NASCAR and two of its top teams has exposed deep cracks behind the scenes. What was once just business has now turned personal, and this week, NASCAR's authority, reputation, and even its future are all being called into question. 2311, Racing, co-owned by Denny Hamlin and Michael Jordan, and Front Row Motorsports, FRM, have been locked in litigation with NASCAR since late 2024. At its core, the dispute centers on NASCAR's charter system, a franchise-style model that guarantees teams entry into races and certain revenue-sharing protections. With the 2025 season looming and charter negotiations reaching a critical juncture, tensions boiled over. In March 2025, NASCAR responded to the team's antitrust lawsuit with a counterclaim. NASCAR alleged that 2311 and FRM colluded, conspired, and attempted to manipulate the charter negotiations in illegal ways. And yet, on October 28, 2025, U.S. District Judge Kenneth D. Bell granted summary judgment in favor of 2311 and FRM, dismissing NASCAR's counterclaims entirely. That decision sends a shockwave through the sport. NASCAR's legal maneuvering has been publicly labeled an embarrassment by observers, and the sanctioning body must now face its critics with its tail between its legs. From the outset, the legal stakes were massive. 13 of the 15 Cup Series teams had signed the new charter agreement. 2311 and FRM refused. They argued that NASCAR had monopolistic power and was unfairly limiting teams' ability to negotiate or compete. NASCAR, in turn, claimed the two teams acted as an illegal cartel to coerce better financial terms. But Judge Bell found that NASCAR failed to prove two critical elements: an unreasonable restraint of trade, required under Section 1 of the Sherman Act, and antitrust injury as a result of the team's conduct. In plain language, NASCAR's counterclaim fell short of demonstrating that competition itself was harmed. The written ruling laid it bare. Joint selling or buying efforts are not always per se antitrust violations, and NASCAR's evidence fails to establish either an unreasonable restraint of trade or that it suffered antitrust injury. The team's attorney, Jeffrey L. Kessler, responded swiftly, "We are thankful for Judge Bell's thoughtful consideration of the facts and the law and his decision to grant summary judgment in my client's favor. Today's decision has only reaffirmed my client's unwavering pursuit of a more fair and equitable sport." NASCAR, meanwhile, issued a statement. "We respect the court's decision, though we respectfully disagree with its legal reasoning. Our priority remains resolving this matter quickly so all parties can focus on championship weekend and continuing to grow the sport. Should a resolution not be reached, we intend to appeal the decision at the appropriate time." The timing of the ruling couldn't be more dramatic. The Championship 4 race is scheduled at Phoenix Raceway this weekend. For NASCAR, the optics are bad. The governing body is fighting in court at the same time its marquee finale unfolds. The sanctioning body's claim to regulatory control is under scrutiny as never before, and the dismissal of its counterclaim undercuts its leverage. But what does this really mean for NASCAR, the teams, and the sport as a whole? First, by dismissing the counterclaim, the focus now shifts squarely back onto the original lawsuit filed by 2311 and FRM. The allegation that NASCAR is a monopoly. If that trial happens in December and the plaintiffs prevail, the sport's structure could change dramatically. Revenue sharing, charter terms, team rights, all of it could be on the table. Second, NASCAR's loss of the counterclaim puts it in a weaker negotiation position. With its threat of counter-allegations removed, the organization may have to settle on terms far less favorable than it hoped. The precedent is dangerous for sanctioning bodies in motorsports and could embolden other teams to challenge the status quo. Third, for 2311 and FRM, this is a vindication. They refused to sign the charter agreement, placed themselves in legal limbo, and risk their spots in the field as open entries. But the court's decision gives them legitimacy. Their argument that the system was stacked in favor of the established teams now has judicial backing. The ripple effects are already visible. Sponsors, drivers, and partners are watching closely. The risk-reward structure for teams in NASCAR has just been thrown into uncertainty. If the governing body can have its legal claims dismissed, what guarantee exists for how things are managed going forward? NASCAR, which has operated with near-complete control over its governance, is being forced into a public recalibration. The cartel narrative it advanced has been rejected by the court. That means the sanctioning body's internal control mechanisms may be ripe for challenge. The sport could be entering an era of greater team leverage, something NASCAR has long sought to avoid. From a brand and reputational standpoint, the sight of one of NASCAR's longtime leaders being publicly outmaneuvered in court is unthinkable, and yet it happened, publicly. Reporters, legal analysts, and fans are describing the moment as an institution being humbled. The question now is, what happens next? The trial is scheduled for December 1st. If either side wants to settle, now is the time. 2 days of mediation failed to bring a settlement last week, but insiders say a deal could still be announced before the season ends. For NASCAR, delaying action could allow the narrative to become damaging over the off-season. The logistics of the charter system itself also come into focus. 23XI and FRM were the only teams to refuse the charter extension. They argue they were fighting for formulaic change to benefit smaller teams, not just because they wanted more money themselves. Michael Jordan said last year, "I did it for the smaller teams as well." Everybody should have an opportunity to be successful in any business. Now, legally, their insistence on transparency and fairness is validated by the court's ruling. And for the fans, this isn't just legal drama, it affects who races, who competes, and how the sport is structured. If NASCAR loses the monopoly suit, the charter system could unravel or be reorganized. That could change fields, revenue shares, team valuations, driver contracts, even race schedules. NASCAR must now deal with the fallout. It will have to either rebuild trust with teams or face increased internal dissent. It will have to defend its decision-making and bargaining power. And on the track, while the engines might roar, off-track, the tremors of this legal verdict will be felt. Make no mistake, this was more than a legal hiccup. It was a public humiliation for NASCAR. The sports leaders found themselves stripped of one of their key supporting arguments, an argument they relied on heavily. Now, the structure of the sport is under review, and the organization's supremacy has just been questioned in court and found wanting. As the season finale approaches and the spotlight turns to Phoenix, the legal echo will still be ringing. Teams will race for trophies, but off-track, the bigger prize might be a redefined business model. And if you think this is just noise, just paperwork and lawsuits, think again. In motorsports, where margins are thin and control is everything, this courtroom verdict could alter the trajectory of NASCAR for years to come. If NASCAR thought it could simply push through its counterclaims and continue as before, they were wrong. Because the court didn't just dismiss them, it exposed a vulnerability. And in NASCAR, where image matters as much as speed, that vulnerability is now front and center. The engines may still fire, the checkered flags may still wave, but the sanctioning body's aura of invincibility has been cracked. For 23XI FRM and their supporters, this is a victory. For NASCAR, it's a humiliating moment that demands rethinking. And for the sport we love, it's a turning point.